So to the extent that we can speak, clearly and slowly, that's certainly helpful. But please feel free.
Your Honor, I am Kevin Strattan, and I stand before you today as a grieving father, asking you to consider the full scope of the danger James Barnes Morris represents to the community, as you said, as bail. My daughter, Brooke, was tragically taken from us by James Barnes Morris. James is not someone who made a single mistake. He is a violent criminal with a long history of terrorizing others. Just 3 days after his 18th birthday in 2017, he began his criminal career. Since then, he has accumulated 17 criminal cases spanning multiple counties in Wisconsin. Among his offenses are violent crimes, including armed robbery, false imprisonment, assault, in which he held a shotgun to a teenager's head and forcibly dragged a young woman into a car against her will. His violent behavior shows he has no regard for the law, for human life, or for the second chances given to him. James was given probation, yet he violated those terms in June 2024. To my understanding, he was then given another chance, an alternative to probation requiring detention at a halfway house. Instead, he claimed he had appendicitis during the last weekend of September and absconded to party for the weekend. On September 30th, 2024, he killed my daughter. While I understand that James is currently serving time for his previous armed robbery conviction and will not be released for another few years, I ask that you will still consider his violent history and his total disregard for the law. His history of escalating violence speaks volumes. He took my daughter's life. And it was not an isolated event. This is part of a disturbing pattern of violence and disregard for the law. My family's desire is that, given the severity of his actions and his complete lack of regard for the law, bail be denied entirely in this case. We believe that he poses an ongoing threat to society and should not be granted any opportunity to further endanger the community. If bail is considered, I respectfully ask that it be set to the highest possible level, keeping in mind the danger he poses. No one in this community should have to live in fear of someone like James Barnes Morris.
Thank you, Mr. Stratton. I appreciate your statement. And I think it goes without saying, but I'll say anyway that I'm sorry for your loss.
Thank you.
The state's position?
The state is requesting a CAF bond in the amount of $1 million. No contact with any family member of BLS.
And Attorney Navy.
Your Honor, I'll note that Mr. Barnes Morris was revoked from supervision. He's serving a 5-year conditional confinement sentence. I don't think that bail is of any consequence at this point. It would be surprising if this case was still pending in 4.5 years. But we will stipulate to the cash bond that the state has requested, given that information.
All right, thank you. I have had the opportunity to read the complaint. I, of course, listened carefully to Mr. Stratton's statements, the recommendations of counsel, which are a joint recommendation, and that's to be given a fair amount of weight. Maybe I'll just make a statement first about the nature of bail, and particularly the nature of bail in first-degree intentional homicide cases. There is a legal provision that allows for the state to request that a person be held without bail, but that I just not even consider the issue of setting either a cash bail or some other form of bail. That has not been invoked in this case. The district attorney has made the decision not to pursue it. And to be fair, I don't know whether Mr. Barnes Morris would qualify. There's some specific requirements, and they're not to be redundant, but they're very specific requirements. They don't apply in even every homicide case. There's also, of course, the practical side of this, and that invoking that process involves a fair amount of additional process. It involves a fair amount of additional showing, and likely not to a particularly purposeful end when the person is already serving a sentence of a number of years and really isn't eligible for release under any circumstance anyway, at least during that time period, of course. So I make that observation because I think I must. It's a fair observation to make about the nature of the offense, and I want to be responsive to Mr. Stratton's point, and I think it's a legitimate one about why we're having a conversation about bail in a case where somebody's charged with the most serious offense that somebody can be charged with in the state of Wisconsin. But that means that I'm obligated to set some sort of bail in the case. Then I'm supposed to set it at an amount that's designed to protect members of the public. It's designed to assure the appearance of the defendant for court proceedings, to prevent witness intimidation, and there's a list of other factors that are also present. Those factors support a substantial cash bail. There's no question about that. The joint recommendation is a very substantial cash bail. It's an amount of money that in my about 30 years or so around the system here, I've never seen anyone post. And it would be a situation where if he posted that, he'd also have to be through serving his sentence, or some sort of significant change would have to occur in his underlying sentence before he could be released. Under those circumstances, I can understand why it's seen as unacceptably low if one was in the position of Mr. Stratton and perhaps other family members, but I think it is a reasonable and appropriate recommendation, and I'll adopt it. So I am going to set cash bail at $1 million. I'll order that he's not to have any contact with any immediate family member of Brooke Strattan. I imagine we should put this on for a prelim right away.
Yes, please.
Okay, we'll get that scheduled for a preliminary hearing. I, of course, wish everybody the best of luck, and that most includes the Stratton family, who I know is still suffering from the loss. And I hope things begin to improve. Take care.
Thank you. Thank you, Your Honor.
You're welcome.
Due to the order to produce, I don't have a lot of options on when to schedule it. It looks like it'll need to be set for next Thursday morning, April 3rd.
Okay, what
9:30. I do have some different times available if that doesn't work.
I have a revocation hearing at 9:30. Do you want me to later? 11.
I could do either 10 o'clock or 8:30. If you want to try to do that before,
Let's do the 10 o'clock.
will do. It's not a heavily scheduled morning, so it'll be sort of awkwardly on the court schedule that it is what it is.
We at 8:30 and a revocation at 9:30. What trial branch?
The computer assigned it to branch 7, Judge White, and then the prelim will be in branch 11.
Thank you.
All right, thanks, counsel.